Good morning, everyone. I hope and trust that the plenary was exciting, and thank you all for being here on a Saturday morning to talk about campaign finance reform and money in politics. It is not often that a Saturday morning involves a room packed with people excited to talk about this topic, so it's gratifying for all of us. I'm Tom Hillbank. I'm a senior program officer at the Open Society Foundations and where I oversee our work on money in politics and constitution and courts. And so this is an issue of deep interest to me. It's hard to open the newspaper without seeing an issue that somehow has a money in politics angle to it. Whether it's mass shootings and the response where people talk about the challenges of overcoming the power and money of the NRA, whether it's talk about carbon limits and the power and money of the coal industry, whether it's in places like New York where we've been trying to pass public financing, small donor public financing of elections there, and we have a real estate industry which gives vast amounts of money to New York State government officials, or obviously in cases like the McCutcheon decision from earlier this year, money in politics is all over. A group called the Purpose Institute recently did a set of studies. They're a messaging and communications firm where they asked a very wide swath of Americans to participate in focus groups and journaling and other activities to really understand how Americans think about this issue. And what they found is that across political and ideological lines, again, across demographic and gender lines, across geographic lines, Americans understand, and in great granular detail often, what the problem is or what they see the problem is. They get it. What they don't know too often is what to do about it, right? Money in politics is as old as politics. So in some ways it's a daunting challenge. So today our discussion is going to touch somewhat on the problem, but really our goal here is to talk about solutions, and every solution has positives and negatives, and no one solution is going to solve the problem. So really what I think, if I have one goal for today, it's that each of you walks out with a clearer sense of what are the possible ways of moving us from where we are now to a better place as a democracy, and where you could plug into that. To help us have that conversation, we have an extraordinary group of people, all of whom are biographied in detail in your programs, but Chara Torres-Spelisi is an associate professor at Stetson Law School. Adam Liaz is the counsel for Demos. Robert Post is the dean of Yale Law School. Wendy Kaminer is a lawyer and writer and columnist for the Atlantic Monthly. And Robert Weissman is the president of Public Citizen. Before we get started, a few housekeeping notes. If you have a cell phone on you, and really who doesn't at this point, please check to be sure that it's silenced. We are going till 12:45, and our goal is to pause at 12:25 to move to a question and answer period, at which point, because this is being videotaped, we do ask that once I call on you, if you wait for a microphone to reach you before you ask your question. So, let's start with this from each of the panelists. From your perspective, what, if anything, is the harm caused by the growing influence and amount of money in politics in the United States, and really where do you see the roots of the problem lying? And let's start with Dean Post.
Well, this goes to the question that you raised at the outset, which is that Americans get it, and the granular question is, what do they get? What's the problem? Is the problem that the wealthy have too much money and too much influence? Is the problem we don't have confidence in government? Is the problem that it distorts the public will? What is the problem exactly? And I think we are in a constitutional mess at the moment, because in Buckley versus Vallejo, the court constructed a compromise between, on the one hand, First Amendment rights to speak, and on the other hand, the integrity of our representative processes. And they enacted this compromise along a distinction between contributions, which could be limited, and independent expenditures, which could be not. Independent expenditures represented your First Amendment rights to talk. Contributions represented the integrity of the representative process. They made this distinction, which turns out to have had very little conceptual underwriting, and now is a mess because we can get around any of the contribution restrictions by independent, quote unquote, expenditures, which are virtually unlimited, and it's as if we never had the compromise at all, and that's what we're facing now.
Okay, Ms. Cowan.
I seem to be in the very small minority of Americans who doesn't get it, but I'm not sure what people mean by the it, and I wanted to start off just to take a few minutes just to make sure that when we talk about campaign finance, when we talk about Citizens United in particular, which has become a symbol of everything that people hate about campaign finance, we know what we're talking about, because I hear a lot of just factual misconceptions. A lot of them you pick up in the press and in what you might consider the very respectable mainstream press, and it's partly a function of the fact that the regulatory scheme that's come in place over the last several decades is so complicated that it's really hard to grasp unless you spend a lot of time with its intricacies. You probably need to be an election lawyer to really know what's going on. I often hear that Citizens United enabled Sheldon Adelson and all the other people who are responsible for the super PACs of 2012. That's not quite true. Citizens United enabled independent expenditures by unions and corporations. It was not exactly the first time, because there had been a lot of soft money coming from unions and corporations in the period before McCain-Feingold was enacted in 2001, 2002. So individuals, as Dean Post has suggested, have had the right to make independent expenditures since Buckley. Now, there were limits on what individuals could do when they got together in groups to make independent expenditures. And the removal of those limits is what enabled the super PACs, which were not mostly funded by corporations in 2012. It was mostly individual money from individual gazillionaires. And when we talk about the problem of campaign finance, I think we should keep in mind that one of the primary things that has enabled what you might consider a really gross infusion of cash from individuals in campaigns are not campaign finance rules, but the extraordinarily growing inequality of wealth, which is determined by a lot of factors. You can say that our election rules contribute to it, maybe they do, but there are many things that are contributing to it. So I'll just mention one more case, just to, if I have another minute,
Sure.
just so that we know what we're talking about. There was a case that followed Citizens United called Speech Now, which involved an unincorporated association of, I don't know, 4 or 5 individuals who wanted to engage in express advocacy through independent expenditures, not direct contributions to candidates. They got a ruling from the SEC that essentially would have classified them as a PAC, a political action committee, which would then have subjected their donors to contribution limits. They challenged that. They were a 527 group. 527 is a provision of the IRS code that was enacted sometime in the 1970s to provide a vehicle for tax-exempt political giving. And the DC Court of Appeals in that case said that a group like this group, Speech Now, shouldn't be, its donors should not be subject to the $5,000 per year limits that are imposed on donors to PACs, which generally give directly to candidates. This was an independent expenditure group. Now, a lot of people will say that that case would not have been decided that way had it not been for Citizens United, because the court in that case seems to rely very heavily on Citizens United. It also cites Buckley. But you should keep in mind that in 2009, before that case and before Citizens United was decided, there was a case, a challenge by Emily's List to some FEC rules that essentially, the details are a little complicated, but it essentially freed up these independent groups to take larger, maybe unlimited contributions from donors that could be spent in elections. So the point is that we're looking at an extremely complicated landscape of laws and regulations, and if you really want to understand what all these cases are and how all of this works, I would suggest that you maybe go to SCOTUS blog where you can find some good commentary on it. If you want to see what the Supreme Court is doing, I think Adam Liptak is always excellent. But I would really stay away from relying on general reports by general reporters about the campaign finance world, because it's very misleading. One more quick example, there was a story in the Times last week about Eric Cantor, which, by the way, you might consider a counterexample to the effect of money on elections, though I wouldn't infer too much from that. And the report said that the report cited corporations that had contributed to Cantor. And I read this and I thought, what can this possibly mean? Because corporations are prohibited by law from contributing directly to campaigns. So that could not have been the case. Now, maybe they found other ways to funnel money to independent expenditure groups. It's really unclear. But you read that article and you think, oh, corporations gave money directly to the Cantor campaign. My bet is they did not.
Okay, Professor.
See,
That's not me.
I'm still just 3 years in, so. All right, so I think if there's one thing that's worse than the barrage of negative, misleading political ads that we've all been treated to over the last couple of years, it's the realization that you may have paid for part of them. And the way that you may have paid for part of them is through your 401k. Because the way that money can get into politics can be totally opaque. And so I look at this from a corporate governance point of view, and I think there are at least 3 corporate governance problems that we have to tangle with post-Citizens United. 1, there's a lack of transparency. 2, there's a lack of consent. And 3, there's a lack of internal controls. Okay, what do those buzzwords mean? Lack of transparency. As a shareholder, I can't see it. Sometimes I can't see it before the fact, I can't see it after the fact. Lack of consent. As a shareholder, no one ever asks me, do you want this to happen or not? Either before or after the fact. And a lack of internal controls. There is, with some notable exceptions, no requirement that political spending go to the board of directors. So my board of directors at these publicly traded companies are supposed to act with a fiduciary duty and protect my interest as a shareholder. Well, if they never have to consider this either, then they can't say yes or no on my behalf either.
Okay. Mr. Weissman, how do you see it? Sorry.
Well, for me, I'm going to step back a little bit. For me, that everybody gets it because it's obvious and true, which is that the system is rigged and that big money flooding into our elections doesn't determine outcomes automatically, for example, with the Eric Cantor race, but shapes the races. It shapes who runs, it shapes what they run on, and it shapes what they do when they get in office. Big money in general. Citizens United, a stand-in for sure. It's not the only legal reason this happens, but whatever, it doesn't actually matter in terms of fixing the problem, has enabled a massive upsurge, enabled and facilitated and enacted a cultural shift that has led to a massive upsurge in outside spending. So outside spending is a decisive feature now in every tight race at the federal level and increasingly in state and local races. So we had $1 billion spent in the last race on outside spending, but it's heavily targeted in the close states so that the outside spenders often are spending more than the candidates themselves are spending. And they are defining the race with their negative ads. About 85 or 90% of the spending is on attack ads. And those attack ads decide how the race is going to be run. This is not a mystery. You can see it in any election you watch. If you're a constituent, you experience it. If you talk to candidates, they all know it to be true. And I don't think there's a great deal of confusion about that. It for sure affects what people do when they are elected, because either they owe the people who helped get them elected, or they're worried about what happens in the next election, and it shapes what they're going to do. So I think exactly as Scott said at the outset, I'm sorry, Tom said at the outset, if you want to understand what's going on with climate change, you have to look at it through the prism of campaign spending. If you want to know why we can't get a minimum wage increase, you've got to look at it through the prism of campaign spending. Now, for sure in Washington now, we've got a huge and deep partisan divide, so there's an overlay with that. But you have to look at the issue of campaign spending. And sort of a last really important feature, I think, to understand, and there's obviously a great deal to be said, but a really important feature is the huge infusion of money into the elections, and especially into outside spending, is concentrated from an incredibly small number of people and corporations. This part is hard to fathom, how concentrated it is. So here are a couple data points. Super PAC spending in the last election cycle was around $650 million. The top 100 donors were responsible for more than half of that. Top 100. Okay? And if you look at where the people came, it's mostly human beings. Where did that come from? It's mostly from Wall Street, or predominantly from Wall Street. That's one. Two, if you look at the McCutcheon decision, which held that there could be no constitutionally permissible limit on the total amount a person can give to candidates, parties, and political committees. So now that the old limit was $123,000, the new limit, if you max out to everything, is either $5.9 million or unlimited, depending on how you think about it. There were only about 600 people who hit the old maximum of $123,000. So probably not in this election cycle, but in subsequent election cycles, we are going to see multi-million-dollar donors to candidates, parties, and political committees. But we know the universe that's going to draw from, and it's a universe of around 600 people or 1,200 if you use a slightly bigger count. It's a really very small number of people who are going to have this dominant impact over what's going on. And here's sort of the last data point on this. And it's for sure the case that there's a massive intersection between the concentration of income and wealth in our society and the concentration of political spending. They go both ways. Right? The dominance of the super wealthy leads to policies that lead to more concentration, and that concentration itself is fed back into the political system. The top 0.01%, not the occupied 0.1%, but the top 0.01% take about 4% of national income a year. They are responsible for 40% of campaign contributions, top 0.01%. So we have a system dominated by a very, very small number of individuals and corporations. And that's the politics that we get.
You want to respond?
I just wanted to make one small factual point, which is that we hear all the time, I get this in emails every day, Citizens United unleashed an unprecedented wave of spending, especially of corporate spending. The rate of increase in spending after Citizens United was pretty consistent with the rate of increase in spending before Citizens United. There was a lot of spending through 527 groups in the years before McCain-Feingold. There was even more spending through 527 groups and then in these 501c4 groups in the early part of this century. So just remember, it's just, again, it's not Citizens United that unleashed this wave of spending that Democrats are raising spending on. The rate of increase of spending has been pretty consistent. It's a long-standing problem, or not a problem, depending on your point of view.
I think that's not true. It went up about 5 times between the 2012 election and the 2008 election. But even if it were true, I don't think it's that important. I mean, the fact is, we have $1 billion being spent, and it's going to maybe equivalent amount in this off-year election in 2014, but whatever, the trend lines are going way up. And you can link it to Citizens United or not. I mean, it's permissible and it's happening. And to me, the fact that it's happening is a clear danger to the functioning of our democracy and a clear danger to achieving all the policies that we want to win.
But it's important not to make claims that aren't true.
So, Mr. Leo.
All right. So my definition of the problem is very similar to Rob's, but it's basically that we live in a country right now where the size of your wallet determines the strength of your voice in our democracy. And basically the way that works is, like Rob has said, we have a very tiny percentage of the public responsible for a vast percentage of the campaign spending and contributions. And there's a lot of very interesting political science research that's come out really in the last couple of years that's really illustrated the effect of this, which is that our government is nearly exclusively responsive to the interests, the policy priorities of the top 1%, 0.01%, you can go as low as 10%. In a very striking finding in a book called Affluence and Influence, when the 10% differs from the rest of the 90% on policy priorities, the 10% trumps the 90% virtually every time. So we have a government that has a sharply different level of responsiveness. The reason why this is important is because the very wealthy have different policy priorities and preferences than do the rest of us, as you might expect. They live different lives, face different issues in their daily lives. And so especially when it comes to core economic issues, and this builds off the point Rob was making about how this is actually a vicious cycle. When it comes to issues about what role the government should play in the economy, should there be a strong minimum wage? Should there be redistributive taxation? Should the government seek to create jobs and help foster employment growth? Or is it better to prioritize lowering the debt and deficit? On these issues, the top 1% feel very differently than do the rest of us, and we see government policies that track that 1%. So I think right now we have a system where you can very easily translate economic might directly into political power. And that really violates core conceptions of one person, one vote political equality upon which this country was built and then transformed, especially through the Reconstruction Amendments, I think. I think that it's in a country where you have the uneasy relationship between political democracy and economic capitalism, it's very important that democracy write the rules for capitalism and not the other way around. And we are fast descending into a system in which the logic of capitalism has taken over our democracy, and the very wealthy get to write rules that keep them wealthy, stall economic mobility for the rest of us, and perpetuate that cycle. And I think that if we don't do something to break and reverse that cycle very soon, we might see some troubling consequences down the road. So that's how I define the problem.
I mean, the metaphor, as I often think about it, is that if we have a free market, if we have a marketplace of ideas, this very small group of people have bought up all the stalls in the market and left the rest of us to sell a few random bananas on a towel outside. And I mean, it's a funny image, but it's a sad image, right? I mean, this is the fundamental idea of that Robert, I'm going to switch to first names, that Robert gets to in his new book is really about this idea of what are the fundamentals of the First Amendment? What are the purposes and what are these ideas? And even if you believe, as we'll discuss and debate as we continue, what is it? How do we think about where we are in terms of even that kind of fundamental value of the idea of a marketplace? One thing I would add is also that just this week, a new study came out by two staunch ACS, one of whom is in the room right now, Renata Strauss and Dan Takagi, who are both longtime ACS supporters, who did an amazing study talking to candidates and campaign officials and donors to really expose in a new way the ways in which there is clear coordination between the independent expenditure groups, the super PACs, and the campaigns themselves. And so if you haven't yet seen this, go online, download a copy, or I'm sure Renata has a bag full of her own copies to give away. So anyway.
Can I just add a word?
Yeah, sure, go ahead.
Last year I had John Kerry teaching my class, and we were asking him, what's the single most important problem you face? He said, Citizens United. He said, when I tried to strike a budget deal, you'd get a deal in the conference committee, and they'd go back and they'd say, no, this super PAC will attack us if we do this, and they'd welch on the deal. And he said, until you can change your funding models, you cannot get agreement because you're always going to be outflanked on either side by the funding. That was someone right in the middle of that. At that time, they were doing the negotiations on the budget deal, on the deficit reduction.
Well, John Kerry also thinks that Snowden is a traitor. And John Kerry was also defeated before Citizens United, partly by 527s, while the ban on corporate funding was still in place. And the super PACs that he's talking about were not generally funded by corporations, so they were not really results of Citizens United.
So one thing that I think is clear is that Citizens United, whether it's accurately or inaccurately expressed, is now the iconic case, right? It's the shorthand. It's the case that I can mention that my father says, oh, Citizens United, right? It's a misperception, but it's gathered this sense, it's coalesced people around the fact that there is a constitutional aspect to this. And I think that's valuable, right? We have a constitution with a First Amendment, with a 14th Amendment, with that embodies values about what we want to believe. And what we're having right now in this country and on this stage is a debate about what are the values and how do we think about what those values are in determining the shape of our democracy. One thing that the Citizens United court very clearly agreed upon is the idea that transparency and disclosure are something that they believe is constitutionally protected and mandated. So why don't we start in really thinking about that? So one of the challenges for reformers who want to address this is currently there are a number of constitutional roadblocks, right? Around disclosure, around spending limits, around regulation of independent expenditures, around coordination, et cetera. But you often run into a constitutional roadblock as Citizens United, Speech Now, McCutcheon, and other cases have exposed. But disclosure remains the thing that we can do. So a lot of people are working on this right now. You're a believer in disclosure as a solution. Can you talk a little more about kind of where you see the value of that and where the promise lies?
I don't actually think disclosure is a solution because I have a feeling it's not going to make all that much difference. But I think that I support it as a principle. I think that large independent expenditures or the source of independent expenditures or the source of large donations, contributions to candidates should be disclosed. I do want to comment quickly on this use of Citizens United as a meme. You know, this is a room full of lawyers for the most part, or would-be lawyers, and I find it really distressing. And I heard this at the plenary last year or the year before on Citizens United, people talking about how convenient Citizens United is as a political organizing tool. I think that's a kind of demagoguery, and Citizens United is a particular case with particular facts. It may alert people to the fact that there is a problem with campaign finance, and I think we all agree that there are problems. If you want to solve a problem, you really have to understand it. And if you misunderstand Citizens United, and if you promote a lot of misconceptions about that case, you're going to make it much harder to come up with a good solution, a workable and a constitutional solution. Going to disclosure, the primary problem with disclosure now is the proliferation of these faux 501c4 groups. These are groups that are organized under 501c4 of the IRS code. They're supposed to be social welfare groups. They are allowed to do lobbying, but by statute, they're supposed to be exclusively devoted to social welfare. The IRS, in its wisdom, decided to say that exclusively meant that no more than 49% of their work or more than 49% of their work had to be devoted to social welfare. And so a lot of purely partisan groups that are primarily concerned with electoral politics and don't belong in the 501c4 category, and this is groups, both right and left, maybe more groups on the right, have been using the 501c4 category to avoid disclosure. Now, there was a bill a couple of years ago in Congress to try to apply disclosure to 501c4s. The reason you can't do that, the problem with doing that, is that there are a lot of what I think a lot of us in this room would consider very legitimate 501c4 groups where members and donors deserve anonymity, going back, say, to the NAACP Alabama case. And as long as there are groups that don't belong in the 501c4 category inhabiting it with groups that do belong in that category, you really can't apply a disclosure requirement to all of them. But the problem is not really that hard if we had a functioning IRS. Because if the IRS were to enforce its rules about groups having to be devoted exclusively to social welfare to get a 501c4 designation, these groups wouldn't be able to be 501c4s. They would have to go back to being 527 groups. If 527 groups are subject to disclosure requirements. And the money migrated sort of in the early part of this century. A lot of what we call outside money, I never know exactly what that term means, migrated to 501c4s to avoid the disclosure of 527s. If they weren't allowed to be 501c4s, they could go back to being 527s. The other rule that the IRS doesn't enforce, and I think this is really deplorable, 501c4 gifts above the limit for gift tax, which I think is now around $14,000, are supposed to be subject to the gift tax. Now, the gift tax is not insignificant. I think that it's tagged to what your marginal tax rate is. But I think it's not unreasonable to speculate, at least, that if really large, if these mega contributions to 501c4 groups were subject to gift taxes, and the gift tax is on the donor, that would be more of an incentive to give the money to tax-exempt 527 groups, and the money would be disclosed. So I think that the disclosure problem is in large part a problem created not by the Constitution and not by the Supreme Court, which has upheld disclosure requirements, but by the IRS.
So if we're going to be lawyers, and I quite agree with you that we should be accurate about how we characterize decisions like Citizens United, let's consider two propositions that Citizens United puts on the table, which is relevant to the disclosure question you asked. The first proposition that you see firmly stated in Citizens United in a way I think that transcends prior precedent is that the only compelling interest the state has in regulating campaign finance is to prevent quid pro quo corruption. That's a very narrow notion of what the state can be involved to do that will affect disclosure requirements in the future. Citizens United is really the case that nails that down. The second proposition in Citizens United is the holding in dicta, but nevertheless the holding in Citizens United, that independent expenditures cannot in any way be understood to corrupt or undermine the legitimacy of elections. Buckley does not hold that. Citizens United does hold that. That's the basis of the later decision in Montana, and that once again will have huge implications for how the disclosure legislation will be evaluated constitutionally. So when we speak about Citizens United, let's speak about those aspects of it as well as the corporation aspects.
Okay. So so for those of you in the audience who are tax lawyers, you now have your mission, right? IRS, rules reform, this is good, right? You thought you were going to be left out, you're right here in the middle. So Chara has been really active, and she mentioned a few of the concerns around corporate governance. I'm sure some of you are doing corporate law work. Chara, could you talk a little about specifically something that both you and Public Citizen have been deeply involved in, which is the SEC rulemaking?
Okay, so there is a petition pending at the SEC, the Securities and Exchange Commission, asking for a new rule on transparency of corporate political spending. So far, they have not taken us up on the request, and soon the public comments on that request are going to hit 1 million public comments this summer. And I hope that when we hit that milestone, the SEC looks in its collective mirror and asks itself, which side of history does it want to be on? And let me give you 2 examples of when the SEC was on, I think, the wrong side of history, and one where they did something really brave. One of the examples of when the Securities and Exchange Commission was on the wrong side of history was in 1951. In 1951, a lone shareholder of Greyhound Bus asked for a vote of the shareholders to desegregate buses. This is years before Rosa Parks sat down. The SEC did the cowardly thing and did a no-action letter that said it's perfectly fine for Greyhound to keep that off the proxy. I think that is the SEC on the wrong side of history. On the flip side, in the 70s, after the Watergate fiasco, which revealed illegal corporate contributions to the Nixon campaign, and I do mean corporate contributions to the Nixon campaign, the SEC stepped in and they did a massive investigation of hundreds of publicly traded corporations, and they found what the SEC called political slush funds in those publicly traded corporations. And after they found this out, the SEC itself advocated for the Foreign Corrupt Practices Act. So that's the SEC I dream about. And, and you know, Stanley Sporkin is my hero. I want them to be bold. I know this takes some guts, but I hope that they want to be on the right side of history.
Okay. So before we get to the constitutional conversation, there are two other efforts that are that have been taking place that I think are really exciting and that really deserve a little time. One is small donor public financing, which has been a big issue in New York State and in New York State politics over the last few years, and Adam can talk about that. And then the other is the People's Pledge, which was part of the campaign in Massachusetts a few years ago. So Adam, can you talk a little about New York, and Rob then talk about People's Pledge?
Sure. So the reason why, the basic concept here is that we can incentivize folks to get involved by matching a small contribution, let's say 6 to 1. So if you give $100, that's actually worth $700 to a candidate. The reason, just starting why this is an important concept. So building off what Rob said, you know, everyone knows about most people know about the concentration of funding behind unlimited outside spending. What fewer people understand is that candidate fundraising is nearly as concentrated. So just as one example, in the 2012 elections, folks who ran for the US Senate raised 64% of their money in contributions of at least $1,000. And that came from, who can guess? Throw out some guesses. What percentage of the American population gave $1,000 to a US Senate candidate? Yell it for the camera. 10%? 1%? Okay, the answer is 4/100ths of 1%. So you have an incredibly tiny slice of people responsible for the majority of money these folks are spending. What that means is that the candidates are spending their money dialing for dollars and focusing their attention on the narrowest possible slice of the American population. And it means they're hearing about different issues and problems than they would hear about if they actually went out and knocked on doors in their districts, talked to constituents, had barbecues and fish fries. So the whole point of small donor public financing is to change the way that people run for office and their incentive structure so you can actually build a viable winning campaign talking to average constituents. Because as Rob already mentioned, I think the most profound impact of money in politics is how it acts as a gatekeeper and filters the process from the very start. If you want to run for office in this country, the first question you have to ask yourself is, how much money can I raise? And that translates right now to, do I have access to a network of wealthy donors who can afford to give me $1,000 a pop? This reform could change that equation, get more teachers and plumbers and folks into the process, and have the folks running for office look more like America, have the experiences that are common to America. It's been shown, for example, in New York, it greatly increases the diversity of the folks who are stepping up to fund campaigns. Similar public financing systems across the country have been shown to diversify the candidate pool, et cetera. So I think this can really shift the equation by providing a path to victory that is not dependent solely upon access to networks of wealthy donors.
Yeah, I think one of the best illustrations I heard is in Maine, which has a clean elections bill. There's a member of the Maine legislature who works at a convenience store, right? Which, when you hear about the fact that most people in Congress are millionaires, the idea that there's somebody who's working at what I assume is a minimum wage job is an amazing thing to think about. What does somebody like that bring to a debate? Much in the same way that people talk about having women in legislative bodies or in other offices makes a real difference to the tenor of the debate. Not the tenor of the debate, but the substance of the debate, right? Different people bring different points of view. Different women bring different points of view, right? We need this kind of diversity in order to have the kind of debates as a democracy that we want, and that's one really exciting.
And just to mention, so the leading proposal on this at the federal level is called the Government by the People Act. It's sponsored by Representative John Sarbanes. It's a really great bill. Not only does it have that matching system, it also has a tax credit for small political contributions, which again invites more people into the process, and some other really great provisions. So check it out.
Okay, and Rob, the People's Pledge.
Well, Tom, you think it's good that a room of people get together on Saturday and talk about campaign finance, but I think it's great about ACS that you're allowed to talk about the SEC of your dreams. People are kind of like, yeah, I see what you're talking about. What kind of person is this? A couple of quick things. On the IRS stuff, I agree with Wendy. So we're working on this with something called the Bright Lines Project, and this is a live issue at the IRS. And the IRS commissioner just this past week said, although they started with a rule to deal with part of this problem, they pulled the rule back because it was flawed and came under wrong text. They're actually going to go back at it, and they're going to get to all three components of what they have to do if they're going to solve the problem comprehensively, which is to decide what counts as political speech. Because if 501c4s can't engage in political campaign-related speech, you got to know what it is. To talk about what percentage of their activity can be engaged in political speech. Absolutely correct that the statute said 0. And we've actually sued them, temporarily withdrawn the suit over that issue. But he's at least going to go after that issue. And the third thing is to not deal just with the 501c4s, which are these social welfare organizations, but other portions of the code, including 501c6s, which are trade associations. The latest iteration of the Koch brothers stuff was they created something called Freedom Partners, which looks like a 501c4 or 527 or whatever, but it's organized as a trade association, which was a pretty clever bit of lawyering. And so we're going to have to deal with the whole thing. And apparently the IRS is looking at that. So I think that's good. And we have a proposal on how to deal with some of these issues at brightlinesproject.org. If you actually are a tax lawyer, if there's anybody in the room, that's a project of tax lawyers, so we're looking for more people from that universe to join in with us. On the People's Pledge is a bigger play, not as big as the public financing, which is the grand thing short of a constitutional amendment. But the People's Pledge was this idea that was innovated in the Massachusetts Senate race in 2012 between Elizabeth Warren and Scott Brown. And the two candidates in that case entered into a voluntary agreement rejecting outside spending on their behalf or attacking the opponent on their behalf. Tell their supporters, stay out. We don't want you on TV or on radio advertising for us or against our opponent. And and it was enforced by this agreement. If you do it, we will spend money from our own campaign treasury, equivalent to half of what you spend, and we'll donate it to charity of the opponent's choice. And either from that enforcement mechanism or just from the clarity of the message, it worked. There was almost no outside spending in the Massachusetts race on TV and TV and broadcast advertising, and to the extent there was, they actually paid out the small amounts to charity. And it had a big impact on the race. So that was a very, very heavily funded race. So it did not keep big money out, but it did keep the outside money out. And it meant that the candidates were able to control the campaign, and that the race was far less negative in terms of the advertising than all the other tightly contested races that were going on simultaneously. So we think it's a good model, and we're encouraging candidates to take it in the 2014 race, focusing on the races that are tight, because that's where all the outside money is coming in. This is a remedy to deal with the problem of outside money. It's going to be difficult, particularly if it turns out the Republicans just have an ideological refusal to engage in this. But the reason it worked in Massachusetts and the reason it might work elsewhere is that the candidates had a shared self-interest in doing it. And they're not going to do it if they don't have a shared self-interest, because principle is not going to trump their interest in getting reelected. But all candidates, even the ones that benefit from the outside spending, are uncomfortable, and this is illustrated in the new report, are uncomfortable with the fact that they lose control of their races when all the outside money is flooding in. And they don't, although negative advertising has its benefits, and everybody who's involved in politics knows that, they'd probably rather a little bit less negative advertising, a little bit less of the sort of childish kind of negative advertising that works, and a bit more focus on the issues. And then when the outside money is roughly even, coming in for and against both of them, we hope that there's going to be an opportunity for candidates to see that that's happening and to agree that they have a shared interest in taking control of their race and keeping the outside spending out. Scott Brown unfortunately said he's not going to take the pledge for his New Hampshire race now against Jean Shaheen. Hope that he might still revisit that. She said she wants to do it. In Alaska, a Republican candidate is saying he wants to do it, so it's actually getting a little bit of pickup there. So I think there's some interesting possibilities that we're going to see in the next couple months if it's able to catch on.
By outside spending, you mean independent expenditures. You don't mean money that comes from out of state to the candidate.
It's exactly right. This is not outside. It's not out of the state spending. It's independent expenditures. It's the money from the super PACs, the 527s,
Or
501c4s,
or
501c6s.
Planned Parenthood or Emily's List or any number of advocacy groups would also, that have independent expenditure groups would also be included in
Absolutely,
that.
absolutely. In the Massachusetts race, the legal conservation, this is not intended to be tilted against just the Koch brothers or anybody else. Legal conservation voters, in fact, that's partly why Scott Brown agreed. Legal conservation voters was going heavily in the Massachusetts race, and on behalf of Elizabeth Warren, and Scott Brown had interest in stopping that. Yes, it applies across the board.
So I think what you're seeing is, even within the current constitutional landscape, there is a lot of very creative, and inherently it has to be creative, efforts to live within the kind of boundaries that current Supreme Court doctrine and other federal court doctrine has set. I think what we're going to turn to now for the next 25 minutes or so, and then we'll move to Q&A, is this question of, should we be revisiting or looking more closely at the Constitution and challenging that Supreme Court doctrine? And I feel a little like everybody's been chomping at the bit to get to that conversation, so here we are. So I'd really like to start. The debate has largely been set up as one of the First Amendment versus something else. And Robert, your new book challenges that idea. Could you talk some about about your view on the First Amendment and how that plays in this space?
Well, I mean, I think if I have a criticism of Citizens United, it's failure to understand what the First Amendment is, even though it purports to be a First Amendment decision. If you look at the majority of that decision, it says, look, we have First Amendment rights. Why do we have First Amendment rights? So we can govern ourselves democratically. So the picture of self-government that you get out of Citizens United is we govern ourselves by participating in the formation of public opinion. The state is responsive to public opinion, and that's how we do self-government in the United States. The picture of self-government in the dissent, and the dissent is also about self-government, is we govern ourselves through a system of representation, which means mediated through elections. We have elections, we elect people who represent us, and that's how we govern ourselves. And the constitutional conflict between the two sides in Citizens United is which form of self-government trumps in the United States, through communicative processes by which we continuously govern ourselves through talking and speaking in public discourse, or through the periodic institution of elections. That's the way the question is framed. That's the way it's been framed constitutionally since Buckley versus Vallejo. And the problem, it seems to me, with those who advocate for campaign finance reform is that when they put interests on the table, they are interests that come out of a system of government which is purely representative. So they will talk about equality, one person, one vote, which is a perfectly appropriate interest in the context of representation, but very hard to cash out in the context of self-government that occurs through public opinion formation. So we've had basically the two sides talking past each other. I think it's time actually for the court to sit down and think seriously about what it means to have a First Amendment and why we have these First Amendment rights. And this will ultimately affect the court's response to remedies like the disclosure remedy, because you see the SEC's rule, for example, about conflict-free diamonds being struck down under the First Amendment. We see this proliferation of libertarianism under the First Amendment, which is quite serious for vast stretches of a regulatory agenda. So let's analyze just very quickly, only on the First Amendment side, what would you have to say if you wanted to protect the First Amendment right to participate in public discourse and have a democracy based upon communication? You'd have to say, I have a right to talk because I have a right to participate in the formation of public opinion, and that's a right of self-government or of democracy, to use Kennedy's words, deriving all the way back to Brandeis, because we assume that the government is responsive to public opinion. If the government is not responsive to public opinion, there's no point in my talking at all. There's no point in my having a First Amendment right that is grounded in self-governance if the government is not responsive to public opinion. So how do we know that the government is responsive to public opinion? How do we make that happen in the United States? We have really only one major mechanism, and those are elections. And that means that there are certain properties that elections must have under the First Amendment, which is to say we, the people, have to believe that elections produce candidates who are responsive in one way or another to public opinion. If that were not true, our First Amendment rights, in the very way that Kennedy explains in Citizens United, would be meaningless. So what does that imply? That implies that Citizens United is incorrect, as is McCutcheon, when they say that the only compelling constitutional interest on the table is the prevention of quid pro quo corruption. Because quid pro quo corruption is an interest about a representative system. It's about the relationship you have to your elected representative. But we're not talking about that now. We're talking about the relationship of the American public in the way that Rob and Adam have been talking about to the government which represents them. Do they believe that their elected representatives are responsive to public opinion? And if that is not true, there is no such thing as an operative First Amendment right, justified by the kind of values that Kennedy and Roberts put on the table. So there's a compelling interest, and there's a lot one can do to unfold that compelling interest in the context of campaign finance reform.
Okay. You take a different view of the First Amendment. What is it that you're concerned about as we talk about challenging the Supreme Court's current reading of the First Amendment?
It's not so much that I would take a different view of the First Amendment. I think that's a perfectly interesting and useful view. I mean, I might take a different view in different contexts or a broader view. I don't think of the First Amendment as being primarily instrumental, which is the way you've described it, but it's an appropriate way to describe it for these purposes. I mean, I see free speech the way I see freedom of conscience and freedom of religion as an extremely important normative value. I don't think you would disagree with that. It's not what we're really talking about here. But I think about it, and if I accept that formulation, and I accept that as a compelling interest, and let me say at the outset, I am really delighted that we are talking about compelling interests that might outweigh First Amendment rights instead of claiming, well, First Amendment rights aren't involved in this at all because money isn't speech. And I hope we can agree with Thurgood Marshall when he said, of course, money spent on political communications in support of candidates is speech. And that doesn't end a debate, but it begins a debate that's much more interesting and much harder. So the problem that I think we confront is that if we accept this formulation of what the compelling First Amendment interests are, we don't find them served by the constitutional amendments that I've seen, which would enable Congress and state legislatures to enact the kind of laws that they've enacted in the past. Let's take McCain-Feingold, which was very broad to begin with, which I think would defeat some of the interests that Robert is interested in protecting. For example, if we want public opinion to be heard by the government, if we don't want it drowned out as we think it may be drowned out by the Sheldon Adelsons and the Tom Steyers and the Kochs of this world, the way that individuals can do that is to organize themselves into independent advocacy groups. Independent advocacy groups are almost always incorporated. McCain-Feingold applied, and this was really, I think, a very serious overreach by the campaign finance reformers, when they were intent on stopping the flow of what was called soft money from corporations and unions into parties. And so they put a ban on what they called electioneering communications by all corporations, not distinguishing between not-for-profit corporations and for-profit corporations. That's one reason, only one reason, why the ACLU, for example, was so vehemently opposed to this, because it would have meant that, say, in the 60 days before a general election, the ACLU couldn't run an ad that might be construed by somebody as lending support to one candidate or another. I mean, it meant that the right of citizens to get together and amplify their voices by sending in $50 a year or whatever your membership dues are to an independent advocacy group so that your voice could be heard by the government, that right was suppressed by these rules. That when you make a rule that applies to corporations in general, you apply it to not-for-profit advocacy groups. So people will say, well, why don't you just take the not-for-profits out of the picture? It was the Wellstone Amendment that was included in McCain-Feingold that, to a lot of people's surprise, included not-for-profit corporations in this ban. I think there are a lot of reasons why they didn't want to do that. One, I think that they would have lost the support of a lot of media, including, not so incidentally, the New York Times, the Washington Post, even though there are always media exceptions built into this. And two, because it's not that hard for people to set up not-for-profit corporations that might be considered by reformers illegitimate in the way, say, that the 501c4s are illegitimate. Citizens United, the group Citizens United, was a not-for-profit organization that wanted to distribute a movie that was very critical of Hillary Clinton before the 2004 election, and that would have been a felony. You know, now imagine that a progressive not-for-profit advocacy group commissions a movie by Michael Moore that's going to be critical of George Bush, and they want to broadcast it in the month or two before the election. They can't do it because that would be a crime. Laws like that, I think, defeat the kind of compelling interests that Dean Post is talking about. And it's, as a practical matter, it's very hard to figure out how you're going to allow those interests to operate, not allow what you might think of as the big bad corporations, the Exxons of this world, to influence elections. It's really hard as a practical matter to do. And then, of course, you get to the media exemption, which is one of my favorite things. You're not going to find any constitutional amendment that doesn't include a media exemption. And what does that mean when GE can own NBC? When we have, you know, these huge media conglomerates, when Jeff Bezos now owns the Washington Post. You know, one effect of it would be to create an even bigger media oligarchy that we have right now, because the media would have more rights than the rest of us. It would also be a very easy exemption to finesse, because I don't think the Kochs or a lot of left-wing gazillionaires would have a lot of trouble setting up media operations. Citizens United, the group Citizens United, now has a media exemption. So, you know, as a practical matter, it's maybe I have a limited imagination, but it is really almost impossible for me to imagine the kind of laws that you could pass under these various constitutional amendments that wouldn't operate against the kind of interests that you're trying to protect. And I want to just make one more point about the constitutional amendments. The one that's now before Congress, the Udall Amendment, says that Congress can, basically says that Congress can regulate spending in elections, the states can regulate spending and expenditures and donations in state elections. Justice Stevens, I think, said something like, you know, there's no reason why we can't put reasonable limits. And I'm thinking, oh, great, we're going to use a reasonable standard because we know how well that worked out for us on the Fourth Amendment. You know, Congress, legislators are not going to pass campaign finance laws that hurt their electoral chances. So we're going to end up what we had for a lot of years with what people talked about as incumbent protection laws. We will also end up under this Free the People, what is a Free Speech for People Amendment, which I like to call the No Fourth Amendment Rights for Not-for-Profit Advocacy Groups Amendment, because people need to keep in mind that the word people in the Constitution is not simply used in the First Amendment, it's also used in the Fourth and Fifth Amendments. So again, you know, I don't disagree with any of this in theory, but I don't think that as a practical matter, the kind of laws that would proliferate under the constitutional amendments that are at issue would protect the interests that we're trying to protect. I think it would expose them even further.
So Rob, Public Citizen has been a major advocate for the amendment. How do you respond?
Well, I wanted to respond both in taking Dean Post's comment about the First Amendment and then talk about some of these practical issues, because I think at the end of the day, that to me, that's the most central thing. On the First Amendment, I mean, there's another way to sort of tell the same story that you were telling, which is to look at the McCutcheon decision. In the McCutcheon decision, Chief Justice, that's the one that said that, I've got done now 30 seconds?
Oh, 30 minutes.
All right.
I got that.
I got a long thing going.
It's only for you. To be at 10 minutes. Anyway.
It's these unfair impositions on free speech that we have.
No, I am. Adam suggested at the beginning that I put out a cup, and every time somebody puts in $5, they get a minute of time. So there's going to be free speech and Q&A, but you're going to have to pay for it. So, go ahead. We do have 10 minutes for this discussion, so just keep
So in McCutcheon, Chief Justice Roberts says, look, you know, Sean McCutcheon, the Alabama businessman, he's a constituent. He's got to be able to give. He has to speak, right? He should be able to speak as a constituent wherever he wants. But the thing is that Sean McCutcheon is not a constituent of senators in 50 states, and he doesn't have 435 members of Congress. So his interest is now far beyond any kind of sort of direct connection to his representative. Justice Breyer, in his dissent, really kind of got to the core thing that Dean Post was saying in response, and he said, for the First Amendment to mean anything, your speech has to count. And if the election system means that the only people's speech who counts are the ones who are able to spend $1 zillion, then we don't have a functioning First Amendment. That we actually need to control campaign spending, not to balance against the First Amendment, but to advance First Amendment values. And so the constitutional amendment that's being proposed, and has now been voted out, by the way, voted out of the Senate Constitution Judiciary Committee Subcommittee on the Constitution, and will get voted out of the full committee soon, is not about balancing, restricting, amending, infringing, limiting the First Amendment. It's about restoring the First Amendment that has been undermined not just by McCutcheon and Citizens United, but by Buckley. And that's why I'm not that interested in focusing exactly on what Citizens United means. We can have the debate, but I want to do more than Citizens United. The world was not okay in 2009, and it's become much worse as a result. So what does this mean sort of in practice? So for me, that's the First Amendment question. The First Amendment issue is, actually, this does advance First Amendment values. And by the way, we're not ceding that money is speech. Money is not speech. And just, right, there is a speech component, for sure, when money is being spent to advance speech, but donations are not the same thing as speaking. And that goes to the thing with Sean McCutcheon. He is free to speak as much as he wants for the campaign spending limit. He can put out as many lawn signs as he wants in Alabama. He can put out lawn signs somewhere else if he's got property right in California. But his ability to spend everywhere is not the same thing as actually talking and engaging in a political race. Now, practically, I think we should come back to what the world looks like, not in the realm of constitutional discourse, although we can't sort of abandon principle, but to be mindful of what the actual existing election system looks like, what we've talked about at the beginning. And there's a reason that 90% of the population thinks it's a horrible problem, and that's because it's a horrible problem. It's a horrible problem. And the candidates know it, the public knows it, even the donors know it. Like the lobbyists don't like getting hit up either. That was part of their deal. And we are not going to be able to do the things we want as a society with this campaign finance system. We're not going to get there. We're not going to deal with climate change, which is the biggest existential threat humanity has ever faced, with this campaign finance system. We're not going to deal with the worst inequality we've faced historically with this campaign finance system. We're not going to get health care for all with this campaign finance system. Whatever. It's not going to happen. So what do we do with an amendment? Or what can't we do right now? Like the world looks the way it is right now. What are the limits in terms of what, with this constitutional jurisprudence, what can't we do? There's a lot of things that we can't do. We can't limit corporate spending. We can't forbid corporate spending, which is going to grow increasingly worse. We actually don't know how much is being spent because all the corporate money is overwhelmingly going through dark money secret outfits. We can't regulate campaign spending for the purposes of advancing democratic self-government or advancing principles of political equality. As the court said, the only thing we're permitted to do is stop quid pro quo corruption, which is to say illegal bribery. We can't impose limits on the total amount that anybody can donate to candidates. We can't regulate the amount of spending by self-financed candidates, which is itself a huge problem. We can't adopt limits on the total amount that candidates and their supporters can spend. We can adopt, and we have to adopt, the sort of small donor empowerment and public financing systems that Adam's talking about, but we can't make those systems mandatory. So they're only opt-in. And if we have a system where we say, okay, if you don't opt in, we'll give more to the guy who does opt in, the Supreme Court says that's unconstitutional too. So that's the world in which we live, and it's an intolerable world. So what does the amendment say? The amendment is straightforward. As it's now reported out of the subcommittee, it says that Congress and the states can adopt restrictions on campaigns, the raising and spending of campaign money by candidates and their supporters, reasonable limits. That's the world that we need to have.
Okay, Adam, so public citizen has really gone into down the amendment road. Demos is involved in other ways to try to challenge the current jurisprudence. Could you talk about that?
Sure, and Demos also supports the amendment strategy, and we've been working very hard on a complementary strategy with allies like the Brennan Center and the Campaign Legal Center. Essentially, the other way to go, so we need to have this restoring of our Constitution, either through an explicit amendment or through a total transformation of how the court approaches money in politics. So like Rob has said, this problem does not start with Citizens United. It goes back to Buckley. I think the central problem here is that the court has been asking the wrong question when it comes to money in politics for decades, and only one question, which is, does this law, is it necessary to fight corruption or its appearance now that's been very narrowed? So what we need to do is to put a whole set of new questions on the table to essentially be able to say, yes, the court should look at whether a law promotes fundamental principles of political equality or all kinds of other types of legitimate reasons why the government, or the people acting through its representatives, might want to rein in big money. So there's a few, Dean Post put out sort of a small version of his book, which talks about one reason why you might want to do that, which is to make sure that people feel that the election process is legitimate and that the government is actually responsive to their needs. There are several other of these kinds of rationales that have been proposed. So a couple of more prominent ones actually build out from the concept of corruption. So rather than having this very narrow and cramped idea of corruption, which is only a quid pro quo exchange, which, as Rob mentions, it's hard to tell what the difference between that is and already illegal bribery. We could potentially build out from that. So Larry Lessig has a theory that many folks have heard of called dependence corruption, which goes to the idea that part of a republic is that the government is dependent upon the people alone, but right now our government has a contrary dependence upon the donor class, the funders, what he calls the lesters. And so the idea, so his idea builds out from that. Zephyr Teachout has talked about the fact that there are structural concerns in the Constitution related to corruption. In fact, the founders were relatively obsessed with corruption and talked about it in lots of different ways and intended a lot of the provisions of the Constitution to be structural barriers to corruption. And so that we should look at the actual structure of the Constitution and say that we can cramp down the role of big money in the name of an overall constitutional scheme that fights corruption. There are other separate government interests that various commentators have proposed. Spencer Overton has proposed an idea that there is an inherent interest in the participation in our government of as many citizens as possible, and participation actually includes financial participation. So when we can do what Justice Breyer has called democratizing the influence of money on the system by encouraging others to get into the field, and if we can show perhaps that huge contributions actually depress participation by giving people the warranted sense that their little $25 gift does not actually make as much difference, then we might be able to use that as a way to push back. And then there's my personal favorite of these, which is to really go right at the heart of the problem, which is to say that a lot of this is about political equality, right? It's about the fact that we live in a democracy that is supposed to respect all of our voices. That is clearly not the democracy we're living in right now. I think it's fair to say that at the founding, liberty was the paramount concern of initially, in response to an over-oppressive monarchy. But that the two things: number one, within the very context of the First Amendment, there are equality concerns, as some of the speakers have mentioned, that you can't have a functioning marketplace of ideas, or that the First Amendment is actually meaningless if your participation is drowned out. And then there's a whole second piece that we need to look at again, which is that Reconstruction changed the nature of our Constitution. I believe it elevated equality on par with liberty as a fundamental American value, and we have an Equal Protection Clause which stands for the prospect that your participation in the society shall not be curbed and limited by race, by gender, also by wealth. There are cases like the poll tax cases that say that wealth and lack thereof cannot be a limiting factor. So we have these other places in our Constitution where we can find these fundamental principles. There are a few other interesting questions that are associated. So one is sort of, do we talk about this within the First Amendment, or do we find other places in the Constitution? And I think a lot of the places have homes in both places. Another interesting question is, what is the role of elections in our society? So Dean Post has already talked about how elections have this specific mediating function. He calls them a managerial zone. There are others that have proposed this idea of electoral exceptionalism, the idea that you can do things within the electoral sphere that you couldn't do in the broader First Amendment sphere. That's just an interesting place to look. Going back to the is money is speech. So I'm with Rob. I don't concede. My view personally is that it's too simple to say that money is property, not speech, and it's way too simple to say that money is speech. The reality is that I think that at the very low level, I would not support a total ban on spending any money because you couldn't buy a marker to make a sign, or you couldn't pay for gas to go to a rally. But at some level, money ceases to become the speech itself, and it becomes the means by which you amplify your speech. And that is a very important distinction. When I can buy $1 million megaphone and drown out other voices, it's no longer my money speaking, it is my money blasting. And that is a distinction we need to recognize. Justice Roberts has time and again in McCutcheon conflated the idea of Nazi rallies and regulating money in politics. And that's a very simplistic conflation of the content of speech and the amplification of speech. And I don't think anyone in this room is arguing that we should be regulating content. I think you should be able to say basically whatever you want. You just don't get to shout it over everyone and make sure that I don't have a chance to say my opinion as well. So there's lots of different ways to go about this. I just want to say one thing about the incumbency protection argument, because this is something that comes up again and again. And first of all, studies have shown that campaign finance regulations do not have the effect overall of limits, for example, of protecting incumbents. So the facts are not there.
Depends on what study you look at.
But much more convincing in my mind is if you look at how campaign finance regulations tend to be passed. When was the last time that a group of incumbents went back into a dark, smoke-filled room outside the public eye, like they do in redistricting, by the way, and pass a very strict contribution limit or spending limit? It doesn't happen. The way that campaign finance limits get passed is either by citizen initiative or in the wake of public outcry and scandal. That's how it happens. It's in response to a drive from the public. If they were so protective of incumbents, then politicians would be running off and passing stricter and stricter campaign finance limits all the time, and you just don't see that happening.
So, Robert, Adam's laid out a lot of the range of theories. Do you want to comment at all on those before we move to Q&A?
Yeah. Adam, as usual, puts on the table a whole lot of really fascinating and important theories for us to think about. And I'm happy in question and answer to talk about them more, but it's very hard to. I think there's the distinction between amplification and speech is, to my mind, questionable. I don't understand what it means. I don't understand why one would put there is an equality portion to the First Amendment. We all have the right to speak equally. That's the point about no viewpoint discrimination, no content discrimination. But at the root of the matter, the First Amendment is not about equality. It's about the ability to speak. It's a liberty, right? And it emerges after the 14th Amendment. We have no First Amendment rights in this country, you might know, that are judicially enforceable until the 1930s. First Amendment doctrine, as any of you in this room would recognize First Amendment doctrine, begins to exist in 1931, 1932. It doesn't exist throughout the 19th century. There are no Supreme Court opinions protecting First Amendment rights before that. And First Amendment rights developed precisely as a way of responding to a state in the United States which had become proto-totalitarian, which is the state after World War I, when the Woodrow Wilson administration tries to form public opinion through propaganda, through censorship, et cetera. And the rights, as we would recognize these rights, are an effort to, in a purely Foucauldian way, resist the governmentality, the government's ability to create public opinion. So it was not created out of an egalitarian impulse. It was created out of the opposite, if we're talking about historically. And I do think in modern terms, it's that interest which is more important. But the most essential thing is to understand where it's relevant and where it isn't relevant. And what we have now is a court which is assimilating First Amendment to classic libertarian arguments against government regulation in all sorts of areas, including campaign finance. And the essential point here is campaign finance is democratically enacted legislation. you better have a good constitutional argument if you're going to strike it down. There is not a good constitutional argument on the table at the present time for striking it down the way the court has. And what we on the left are going to need is, one, a First Amendment that protects what we want protected, and that we need a theory of. And second, one that doesn't overreach and strikes down everything the SEC is doing, as well as everything we're trying to do in campaign finance. So we want to walk that line. It's an extremely important line for the left to walk. If we walk too far on one side and collapse the First Amendment into an egalitarian argument, we will lose a lot of its points in a modern world with an overarching and a very aggressive government. And if we walk too far toward the libertarian side, we will lose the ability to have collective self-government, which is one of our most important values. So I would say we need to think very carefully about what we want here.
Okay. So we have 15 minutes left. I'm sure many of you have thoughts and questions. I just ask that you try to keep them brief, and we will try to keep our responses brief to give as many people a chance to speak as possible. In the back, just please wait for the microphone.
Hi, Zaid. So my question has to do with practical, on the ground today. We have elections coming up. We've got 2016 coming up. I understand we don't want to have all this extra money, independent groups, et cetera. But what do progressives, what do Democrats do when they're facing this barrage of conservative super PACs? And there are some Democratic super PACs or progressive leading super PACs as well, but not as organized. And there are a lot of people, a lot of big donors on the Democratic side who say, I didn't like Citizen United. I don't like all these independent groups. I'm not going to give to them. And it's sort of like you're damned if you do, damned if you don't. Because if we don't do anything, then there is this barrage of attacks. It's ongoing. We saw it in the Affordable Care Act legislation. We saw it in 2016. Didn't affect, obviously, President Obama winning, but it did affect the way that Congress looks like, the way that the Senate and the way that the House looks like. So what do you tell, for those of you who are against this extra money, the independent spending, what do you tell progressive groups, Democratic sides, to how they are going to actually fight on the ground and not just theoretically whether or not you agree with these groups?
So who would like to respond?
So I'll say just first that, so Demos is a 501c organization. We don't do anything in the electoral sphere, but we also don't advocate for unilateral disarmament. So, I mean, you're in a fight. I'm not going to blame you for playing by the rules of that fight. However, there are ways while doing that to hold candidates accountable for their positions on this very issue to fix the system. So, for example, there's an effort called Friends of Democracy, which is a super PAC to end super PACs, right? So, I mean, I think that
Its tagline is "Embrace the irony."
right, exactly. So I think that while it's not something that we do at Demos, there needs to be a price to pay for politicians who are protecting the status quo and keeping the big money system. That doesn't mean you can't play in it, but you better have the right position to change it if you eventually win by those rules.
First, I don't think you can blame the makeup of Congress now on Citizens United and Super PAC spending. I think you can blame it on what happened in 2010 when Republicans took the state legislatures and gerrymandered and fixed the House for what may be another 10 years. And I think that was probably less a function of more right-wing money coming into the system than of Republicans paying more attention to what was going on the ground at the state level. But I want to make another point that nobody has discussed here. I mean, there's this general sense that all this big money, a lot of it coming from the right, is drowning out public opinion, that people can't make their voices heard, they can't make their preferences heard. And nobody's mentioned that the primary way that individual citizens make their preferences known is by voting. And we have abysmal voter participation. Now, you can say that people aren't voting because they're discouraged by so much money in the system, but people haven't been voting in large numbers for a really long time. And the voter suppression that's going on now has a lot less to do with money in the system than with all the voter fraud and outright voter suppression efforts and what's going on with the Voting Rights Act. So when we talk about campaign finance, though, we really need to talk about voters as well. And what's the responsibility of voters? To just get out there and vote. and make their preferences known that way. And what's the responsibility of voters not to be taken in by these ridiculous ads that we all see on TV? I mean, how many of you base your votes on the ads that you see on TV? And if you're not doing it, why do we assume that so many other people are doing it? And if they are doing it, then why isn't it partly their fault for not being better informed?
Raise your hand if you buy Pepsi because of the ads on TV. People don't think that they're doing that. That doesn't mean that it's having an influence.
Okay, another question. Yes, in the front.
Thank you. My question is sort of along these lines that we've been talking about of voices being drowned out. And I think there's a really interesting dynamic happening right now where political parties themselves, as entities at the state, local, and national level, feel that they're getting just as drowned out as people. With the influx of independent expenditures and this idea of controlling the campaign. And I think it's an interesting sort of practical argument, but right now, just recently, they've started an actual legal argument where lawsuits have been filed on behalf of the parties to basically say, okay, we want no limits too. We're now unfairly harmed by this system, and it's all become elevated to a constitutional right of parties. And I kind of wanted to get the panel's view on that and whether there's this new right that's been created that now that is being infringed on from the party perspective.
Can I say just two things about that? I think if you look at the history of American self-governance, from about 1828 to about 1896, we did our self-governance through party structures, which were comprehensive in our politics. In the progressive era, parties collapse. Parties are regarded as machines. And I think the First Amendment that we have, which is unique in the world and more severe than the First Amendment of any other country, is tied to the weakness of our political parties. So our politics generally occurs outside of the realm of political parties. And I think we need to think a lot about what we want political parties to do in this country, what their role is. That's the first thing. And the second thing, this metaphor of drowning out, which has as its sub-metaphor the metaphor of balance. Everything's. I've lived a long time and watched any number of left-wing metaphors get taken over by the right wing. So postmodernism starts as a left-wing thing, and now, if you believe that there's climate change, and I don't believe that there's climate change, everyone is entitled to their opinion. And I think this notion of drowning out and this notion of balance is a very dangerous notion. I do a lot of work with academic freedom, and I see any kind of claims in universities. You teach evolution, but we need balance. We need to have the other view there too, because evolution is drowning out in biology the views of those people who believe. You see this metaphor all the time, and if you start applying this metaphor seriously without thinking carefully of exactly what it means, and it's a very hard metaphor to know exactly what it means, it's going to turn on the left big time.
Can I
And already
respond to that
has
briefly?
in many areas.
Of that. I mean, but in your classroom, right, if you have one student who goes on and on and on, there's a point in a seminar where you say, okay, we've heard from you, right? And your book talks about town meeting structures, that we have structures within democratic practice, whether it's in a courtroom where two people very unfairly get equal time to speak and argue in front of the Supreme Court, or in a town meeting where you say, look, we want to be sure that all the points of view. So how do you deal with that?
You have to deal with that in the following way. So there are particular structures that have particular purposes, and the allocation of time that serves those purposes is the appropriate way to allocate speaking time. So you need an account of purposes. In the general election, what are the purposes? If we just use this metaphor generally of drowning out, it will come back. I see it come back all the time in university contexts, in other contexts where you want balance. And balance, nicotine does cause cancer, nicotine doesn't cause cancer. Balance is not a recipe for truth, and it's not a recipe particularly for politics.
And it's not a First Amendment value.
Well, can I just, on behalf of the drowning
It's an
out,
education value, but
Yeah,
not a First
but
Amendment.
not a First Amendment value.
Yeah.
Can I respond to the party question, please, which she asked?
Go ahead.
I think McCutcheon was a good decision, partly because I think it was rightly decided, but as a practical matter, I think it has the potential to take more money into parties where it will be disclosed and maybe take some money away from the dark money groups. I also think we should, I don't think it's going to make all that much difference as a practical matter. I've seen the way donors operate. They tend to give ideologically. All McCutcheon said was it lifted the aggregate amount that you could give. It didn't lift the amount that you could give to an individual candidate. It mounted that it increased the number of candidates you could max out to. I think that's going to be good for parties. I think the weakening of the parties that followed Buckley's decision that you couldn't limit independent expenditures, but you could limit contributions to the parties, is donations to candidates, is part of what led to the explosion of these independent expenditure groups, which people don't like. You know, if I were queen, I might lift all the limits. That might not work now. It might be too late because these independent expenditure groups don't really want to give up control and go back to the parties. As to parties having their own rights, you know, that's a difficult question. I'm not going to answer that off the top of my head.
Parties are people.
Two.
Well, they do have their own rights, but I'm not sure in this
More like
context.
people than corporations. That is the next play, and it's part of a long, right? It's part of James Bob's long thing. They might win. I can't believe you said McCutcheon is a good decision, and I want to say, both
I thought Citizens United was a good decision. There you go. Can you believe that?
No.
I didn't think so.
Because
This panel would be boring if she wasn't saying those things.
no, because I can make jokes even if it's okay. Not even funny to me.
It's not a joke.
I'm sure that is a fact. The McCutcheon decision, the jurisprudence is there's no permissible basis for limiting campaign donations except to stop legalized bribery. And to me, that's sort of mind-blowing as a First Amendment principle. And it's self-evidently super destructive for the functioning of our society. I want to comment on what it's going to mean practically. It is not going to take money from dark money groups and give it to parties. It's going to mean there's going to be more money that also goes in through the McCutcheon-created venues, which is not 500 individual checks written. It's through something called joint fundraising committees. There's going to be multi-million-dollar contributions that are going to be written in 1 or 2 checks. Who are those checks going to be written to? They're not going to be written to 500 candidates. They're going to be written to party leaders who are going to control these joint fundraising committees. Who are those party leaders going to owe their allegiance to if they're taking multi-million-dollar checks? They're not going to do it to the broad public, to the 90%, right? They're going to owe it to the few hundred people who can write those multi-million-dollar checks. That is going to be, with a high level of certainty, the practical impact of the McCutcheon decision. It is going to make things dramatically worse. It's not going to stop the outside spending. It's not going to reduce it, but it's going to create a new and worse problem.
That remains to be seen, but the money will all be disclosed, if that's any consolation. If it goes to parties.
So we are quickly running out of time. There is one thing I do want to say that Adam did not, specifically around efforts to change the jurisprudence and what's happening there. There is an effort that he mentioned, DEMOS, CLC, the Brennan Center, and other organizations are all a part of to help foster scholarship and other new ideas about what our campaign finance jurisprudence should be. There are efforts to bring litigation to both defend existing limits and defend policies as they get passed. This includes an effort to ensure that the nominees that we get on our federal courts, the people we get on our federal courts, are going to have democracy as a central concern for them, and change that, particularly as in the next administration there will be 4 judges over 80 years old, 4 justices over 80 years old on the Supreme Court. And then finally,
That's young.
an effort, right, exactly, they're very young.
I hope to be over 80 someday.
Me too. So, and then finally, very much a popular constitutionalism effort. Most people agree that the First Amendment does not mean you can't regulate campaign spending. And the Supreme Court, as the NRA did, we need the people's voices about what the Constitution means to play a bigger role in our debate. So those are all, you've seen lots of ways in which you can get involved. This is a conversation which should continue. You've also seen that there are these are big values and these are big problems, and they're things that we should be walking forward on very carefully, right? There is not an easy answer and there's not an easy solution, but there are solutions. And hopefully next year when we all get back together to have this conversation, many of you in the room can talk about the work that you've been doing over the last year to help challenge the problem as you see it. So thank you to our panelists. And then I just want to say, this is an event that exhausts the ACS staff and the volunteers who participate in it. So in the next few hours, as you see ACS staff, and I specifically want to thank Jesse Grauman, who did an amazing job helping prepare for this panel. But if you see ACS staff members and volunteers, thank them for putting together this weekend. They're all deserving.